Hey everyone, welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, Mike and Alex Ooley of the Ooley Law Offices in Indiana. Gentlemen, thank you for coming on board today.
Thanks for having us again, Paul.
Paul, it's always a pleasure. Thank you.
I need to get social media hooked up and running here. Give me just a second to do that. Okay, and bring that on. There we go. All right, we've already got social media comments coming in. What's going to happen today, folks? Briefly, I'm going to talk about two news stories, and I mean brief. I want to be through these in just a few minutes, and then we're going to talk with Mike and Alex about the topic of the day. The two stories I want to talk about briefly are that the Tennessee governor, and I forget his name off the top of my head, but the governor of Tennessee has signed constitutional carry, what I prefer to call permitless carry. It will go into effect, it will be law of Tennessee on July the 1st. Also in Arizona, no, that one was, in Texas, they're copying Arizona. They are pushing hard for a Second Amendment sanctuary state law. As far as I've been able to see, there are 3 states that are Second Amendment sanctuaries today. And that is, well, they will be, Arizona will be, Montana is one, and Alaska is one. Texas wants to join the club. Texas pushed out of committee. The bills made it through the House. It was in committee in the Senate. It now goes to the floor, and the Texas governor has been calling for it. So we know as soon as it hits his desk that he's going to sign it. The one thing that's interesting about the Texas bill is it says any individual police officers that help enforce gun laws from the federal government going forward can be criminally charged. That is the only part that worries me. You guys, Alex, Mike, do you guys want to comment on either of those stories, and then we'll get into why we're really here today?
Yeah, with Texas potentially declaring itself a sanctuary state. I think we've talked about this to some extent previously. There was this huge movement with counties around the country in various states declaring themselves sanctuaries, but those were mostly symbolic. But these states who are declaring themselves sanctuaries, those might have more teeth. And while you're right, I mean, the provision about criminalizing police action to enforce what they consider to be unconstitutional laws could be an issue that does give it more teeth. So I'm a little torn about that provision, but it's an interesting one that gives it some more leverage.
Yeah, I think you bring up a great point, Paul. I sort of have some trepidation about putting police officers in a situation where they've got put in a situation where it's not clear whether they're going to be prosecuted or not under a particular set of circumstances. Their jobs are tough enough the way it is. So I do have some concerns about that, but overall definitely support the movement towards state sanctuary notification, or states recognizing that they're going to put a stop to federal encroachment. And who knows, maybe it'll be like a constitutional carry. That started out very slowly, and now it's grown to lots of states, and maybe the sanctuary movement at the state level will do the same thing.
Yeah. And from a story I wrote earlier today that I just checked and is still in my editor's desk, it hasn't hit yet, but I do know that one more state, Wisconsin, is looking to be the bill should be introduced this week in Wisconsin to make Wisconsin a Second Amendment sanctuary state. That's a little surprising for me, simply because it took them so long to get concealed carry. It took Wisconsin. They were the next to the last state behind Illinois to get it. And that was amazing to me that they wanted the Second Amendment Sanctuary Act so quickly. At least one legislator does it that's introducing it.
Yeah, I don't know what the culture is behind that. That's interesting.
Well, knowing what I know of Wisconsin, Wisconsin is a fairly red state, but they've got a huge blob of blue around Madison. And Madison, kind of like some other states, is controlling. And Detroit, not Detroit. Green Bay is obviously, and so Milwaukee. I cannot think today. Anyway,
It's Friday, Paul.
I want to get one comment in here before we go off to the topic we had on the schedule to talk today. But this is a great comment from Valentine. He wants to know, what are your thoughts on the potential court packing that may occur? Do you think SCOTUS will try to take a Second Amendment case before they're packed? You guys know law much more than I do, but I do know there is at least one case from California that they are considering that is supposed to be announced whether they're taking it or not next week, that deals with right to carry.
Well, I certainly, and first of all, I would definitely defer to Alan Gottlieb on this, but I certainly would expect the Supreme Court, with the current status, with Amy Coney Barrett now, I would expect them to take a case. Some of the justices have been pushing to take a Second Amendment case. I'm thinking about Clarence Thomas. So I certainly hope so, and I would expect them to take a case before long. Alex, do you?
Yeah, no, I agree with that. I think many of the, I don't know about many, but several of the justices anyway, believe that it's long overdue to define some of the parameters of the Second Amendment and the rights that it protects. And there are lots of violations of our Second Amendment rights going on out there every day. So I think the Supreme Court will step in and start to weigh on some of those issues soon.
Yeah, and thanks to the Second Amendment Foundation, I think it's what we used to say is it's a target-rich environment for the Supreme Court to pick a case and take it and make some law in this area and stop treating the Second Amendment like a second-class amendment to the Constitution.
Yeah, absolutely.
With respect to,
go ahead.
Well, with respect to the court packing, I know that President Biden, at least I think President Biden today or recently, has decided that he's going to, in some form or fashion, he's going to study the possibility of changing the composition of the Supreme Court. I certainly hope that that's just trying to check a box to say that he's doing what he campaigned on and nothing will come of it. I think there's going to be enormous uproar if that occurs, or even a real legitimate attempt to pack the court occurs.
What they have to do to pack the court is get 60 votes in the Senate. They have to, oops, I got the wrong one there. They have to change federal law to do it. Not a bill, not a spending bill. Spending bills and things like that, they can do with 51 votes. Now they can do judicial appointments with 51 votes. But to change the makeup of the Supreme Court, they're going to need 60 votes out of the Senate. That's not going to happen for at least 2 years. Lord willing, never.
Right.
Amen.
But let's go ahead and let's talk about the real reason I brought you guys here today. And we may go long because we're already 10 minutes into the show with something I planned on maybe 2 to 5 minutes on. But you folks are attorneys. You are attorneys in Indiana, and you handle self-defense cases on at least an occasional basis. One of the main topics when I went through training, and it varies a lot, is from trainer to trainer what they advise. You've just had to use your handgun in self-defense. The police are going to become involved. You're going to be talking to them. What do you do when you're approached and you have to talk to a police officer?
Yeah, so just starting out, I want to emphasize, obviously, we're just giving this information for educational purposes. We practice in Indiana and can't give legal advice, obviously, over the internet. But this is what people need to understand, is that this may be in the context of what's called a defensive gun use, not necessarily a shooting. So you may not have discharged your firearm at all. And as we know from various studies, there's a lot of discrepancies in these studies, but people use their firearms defensively for protection, as many as 3 million times and as few as 500,000 times. There's quite a bit of discrepancy in the studies, but most seem to support the assertion that there's at least 500,000 defensive gun uses annually. So it's a significant number, and most of those do not involve the discharge of the firearm. But nevertheless, if a gun is involved in a self-defense encounter, there are some legal issues that you need to be aware of and some practical issues that you need to be aware of. And so that's what we want to talk about here today, is kind of the aftermath of that self-defense encounter, whether or not there's a discharge of the firearm.
Yeah, and I think it's important that folks understand that we're talking about a defensive gun use, and that may involve the discharge of a firearm. But in our experience, a lot of these defensive gun uses, and there may be millions of them a year in this country, but these don't necessarily involve the discharge of a firearm. It could be just putting a hand on the firearm. It could be drawing the firearm and having it in some retention position, low ready. So that's the vast majority of cases that we see or that we encounter, and people need to prepare for those as well. Also, for context purposes, I think folks need to understand, you may be trained up, may have a 1.5 second draw and be able to put, 2 shots on an index card at 5 yards. You may have the skills of, Rob Latham, but you need to apply the same energy and the same effort to the aftermath of a defensive gun use. And a lot of times people don't spend as much effort with respect to the aftermath. Another thing, I think, just before we get into some specifics, understand that this is going to be a highly stressful and chaotic situation. And as human beings who may not have experienced something like that before, at least to that degree, we're going to have this chemical dump that occurs. There's going to be these enormous physiological changes in our body. It's really this freeze, flight, or fight status that we take to this highly stressful situation. We may have auditory exclusion. We may have a tunnel vision. Our heartbeat's going to beat rapidly. We're going to have rapid breathing. We're going to lose fine motor skills. We may lose our major motor skills. We're going to revert to a great extent, depending on how much training we have, to our primal brain, so to speak, and our reactions are not necessarily going to be what the legal system expects them to be in such a stressful and chaotic situation. And I think it's so important for people to really think through these situations and apply as much effort to the aftermath of a potential self-defense case as they do to the marksmanship, gun handling, and safety aspects of it. Of course, the most important thing, the way to win any fight, is to avoid it. That's when we have success, is when we avoid situations like this. And Paul, I've talking a lot, and we can keep going on. One thing I want to say before we go, Alex and I, we have a great deal of respect for Massad Ayoob. Mm-hmm. Much of what we say today, and I think you're a graduate of his Mag 40 class as well, perhaps, much of what you hear today will be an influence from Massad Ayoob. So we would encourage folks to seek him out and seek his training as well. Because some of what we say today may not necessarily be what the vast majority of attorneys would say in most jurisdictions.
Let me get a couple of social media comments up, because I think this is what most attorneys would want you to do. I'm going to put this one up. Guns and Barbecue says, I feared for my life. I want my attorney. And after that, say nothing.
Well, there's certainly a good argument for that. That's one of the, it's kind of actually a hybrid there, because that person advocates saying something. But if you've heard from most criminal defense attorneys, they would say, don't say anything at all. But what you have to understand about criminal defense attorneys is that they represent people who are generally guilty. 90 some odd % of the clients that they represent are guilty of something. maybe not everything they've been charged with, but something. So if you're guilty, it's absolutely a good idea to say nothing. Okay, but if you're truly innocent, there's a train of thought, and this comes from Massad Ayub and others, where you should say something. And the question is, what is that? What should you say?
And by the way, there's some criminal defense lawyers out there, and rightfully so. They're jumping up and down right now saying, do not listen to these two guys. The only course of action is to keep your mouth shut and invoke your Fifth Amendment rights. There is nothing good that ever comes from talking to the police. And I'm not going to say that they're wrong. You have to make a decision on your own about what you're going to do in the aftermath of a defensive gun use. And I think to a great extent, it's going to that question needs to be informed by the amount of training you have, because you certainly have the right to remain silent. And that's probably the best general rule to follow. But there are other folks like us that think if you're trained and you think through it, there are some limited things you can say. Though now we're not advocating that you waive your Fifth Amendment rights. We're just indicating you want to judiciously use your Fifth Amendment rights. So folks are going to have to make that decision on their own. They're going to have to think about it ahead of time and decide what they're going to do ahead, before the incident occurs. And we probably ought to talk about. Go ahead.
What does a judicial use of your Fifth Amendment right look like? A judicious use. What does that look like? Let's just take a theoretical example and follow it through.
Yeah, so if you've been involved in a defensive gun use, and it's a high stress situation, some people will suffer from logorrhea of the mouth from saying too much. But if you can say a little bit, that can go a long way to helping out your future defense counsel in assisting with your defense if you're truly innocent. Yeah. So to the extent that you can point out witnesses that might be good witnesses on your behalf, to the extent you can point out evidence, like there's the guy that attacked me, there's his weapon in the bushes or whatever. Just point out little things that will be useful to law enforcement when they arrive on the scene, and your attorney in your future defense.
Well, let's just go through it in order, Paul, if you want to. Let's start. I want to start, if we can, with a 911 call. I mean, obviously, we're going to make the 911 call. So when we talk to the 911 operator, at least by proxy, we are in effect talking to the police. So I don't think even the most ardent criminal defense attorneys who want you to remain silent wouldn't tell you to make the 911 call. So we need to think about what we're going to do on that 911 call first. I think is the most important thing. And that is, when we make that call, first of all, we're probably going to have to make it from the scene. Don't leave the scene of the defensive gun use unless there is some danger to you or your family that would compel you to leave, because flight from the scene sort of implies some sort of wrongdoing. So we want to stay at the scene and make the 911 call. And when we make that 911 call, there's some difference among attorneys as to what you should say. But I think you want to identify yourself. You want to identify your location. You want to identify the fact that perhaps you were attacked and there was a crime. And then at that point, you probably want to also describe yourself. I'm wearing a black shirt, blue jeans. I'll have my hands on a white Ford pickup truck. And you might want to do that just for safety purposes, because remember I talked earlier about these physiological stressors that you're going to be under. Well, guess what? The police officers, at least in many instances, if not most instances, are going to be very stressed out when they're coming to this scene and they know there may have been a discharge of a firearm. So you've got to do everything you can to keep the situation safe. The police officers don't see that halo over your head. Mm-hmm. So safety is of paramount concern here. So I think those are the most important things about the 911 call. That's your chance, to begin the process of you being painted appropriately so as the victim, because I'm kind of talking a lot here, but because when you make that call to 911, we want it to be the first. You need to call first, and the system at that point sort of identifies you as the victim, and anybody else that calls in after that is sort of labeled by default as maybe the criminal. So we want to be the first to call 911. It's a race to the phone to call 911.
It certainly is.
And
if I
one
could,
other thing about I'm sorry, Paul.
I want to bring up one thing real quick. I'll give it right back to you, Mike. And that is, unless you happen to be living or unless your incident happens to occur in Memphis or downtown Chicago, police don't respond to shots fired every day. They're going to be, this is an unusual occurrence for them, and they are going to be pumped up on adrenaline, and they're going to be getting there as quickly as they can. You want to try to make sure my opinion is you want to try to make sure you look as much like the good guy as you can. And for the love of God, do not have that gun out. Have it holstered or in a safe place when they get hit there.
Absolutely. No sudden movements. Like I said, they don't see that halo over your head, and you need to let them get acclimated to the situation and get comfortable, because they're going to be they're going to go through that adrenaline dump as well. So incredibly important that you do that. With respect to that 911 call too, and I think this is even more controversial, do you stay on the phone or do you hang up? I think generally speaking, and Alex, maybe you can comment on that. Alex and I sort of debate this sometimes. I think I'm a little lukewarm on this, but it's probably a good idea, depending on the context, to hang up. I have heard some 911 calls where I think, for instance, somebody is in someone else's home, the criminal is in the home. Staying on the call might help avoid you shooting the police, for instance, if they make entry into your home. So once again, that's going to be something you're going to have to decide what's right for you in terms of whether you hang up or stay on the line. Please remember that the 911 call is recorded. I can tell you there are instances where folks were all amped up. They said things that were the result of adrenaline, and those things were used against them later. And they were relatively innocent, really, but they were still used against them because of what they said on the 911 call. So keep in mind it's recorded, and I'm not an expert on 911 infrastructure, but it's my understanding as soon as you dial, the recording starts. It's not when the operator picks up. So keep that in mind.
Yeah, I mean, the argument to stay on the line, obviously, is that if the dynamic at the scene changes for some reason, you'll have the 911 operator on the line as the same one you've been in communication with. You can provide them updates from the scene if things change, or you can let them know, hey, I see the officers arriving on scene. Maybe then you hang up. That way you can make sure you keep your eyes on potential other threats, and that you can get your firearm put away before the officers actually arrive.
Yeah,
one trainer and I think told me at one point to once you've given the information you need to give, to leave the phone connected, but set it down and pay attention to whatever else you need, but leave the connection going and just set the phone down. I thought that was an interesting idea.
Yeah, I think that sort of splits the difference.
I like that idea, because one concern you have about staying on the line is that 911 operator is going to try to pump you for information. And that's a situation where you don't want to give more information than what's necessary, because remember, like we talked about earlier, it is recorded. So you just want to make sure that you give the operator the information that is necessary to make sure that the police can arrive on scene and know who you are, and so that the situation can be handled in the safest way possible.
Yeah, and safety is of concern, and like Alex said, we're concerned about what you say, and we're not saying that because you're a guilty person and we're afraid you're going to incriminate yourself because you're guilty. We're concerned because, remember, I said you're going to have time. Maybe I didn't say it, but time gets distorted when you're under stress. You have tunnel vision, auditory exclusion. We know that it's going to take 2, 3, 4 sleep cycles before you're going to remember the event as accurately as you can. So the fact of the matter is, you've got to be very careful about making statements under such high stress situations, because you will simply make mistakes, and those mistakes can be used against you. So that's our concern, not that we're trying to hide some guilt.
All right, we're rapidly approaching the 30 minutes we have, but I want to get and we may go a little long, but I want to get a couple comments out here. And John, on Facebook says a lot of police officers do not have to give a statement for 24 hours per union contracts. John, it's actually longer than that. If I'm correct, it's 72 hours. It's 3 days and at least 2 sleep cycles before.
Yeah, and that's the key. That's the key point. There is the sleep cycles, because what we know is that your memory of a high stress event or a traumatic event is actually better after you've had 2 sleep cycles. And those contracts, those police unions know that's the case. So they want their officers to have had some sleep cycles before they give a statement.
Yeah, and one thing that we want people to consider anyway is if they opt to go with the second option where they're going to try to say a little bit, what we're really advocating is that they take the same approach that probably most police officers trained to take, and that is they're going to try to establish, once again, I'll use Mass's words, that the active dynamic at the scene. In other words, you're going to say when the initial officers arrive, hey, that man attacked me and I had to defend myself. You're going to also indicate that you'll cooperate in the prosecution of the perpetrator and the criminal. You want to point out the evidence. Alex has already talked about this, because evidence disappears from scenes. It gets disturbed, and we want to make sure we preserve exculpatory evidence. And we're going to point out witnesses, because witnesses don't want to get involved. Witnesses go away. Witnesses forget things. So if there are exculpatory witnesses and exculpatory evidence, we need to point those out. What if the perpetrator threw the knife in the trash can? I want the police to find the knife in the trash can that he threatened me with. But ultimately, that's all we're going to do, except say, officer, you know how serious this is, and you'll get my full cooperation after I have a chance to talk with my attorney, and that's it. No more. Invoke your Fifth Amendment, and continue to invoke your Fifth Amendment until you've had a chance to consult with your attorney and have those 3 or 4 sleep cycles, just like we expect the police will probably do, and rightfully so.
Guns and Barbecue over on YouTube says you can't talk yourself out of being arrested. However, you can talk yourself into it.
That's absolutely true. Absolutely true. And the only thing we're talking about is to try to establish, once again, this active dynamic, and to preserve evidence and witnesses that may provide exculpatory evidence to preclude maybe even us getting charged or convicted.
And we can go on for a long time here about the aftermath, but that's a good point, or that leads to a good point, that if there's a defensive gun use, you need to be prepared for the possibility that you may get arrested, and have some contingency plans in place in case you are arrested and are held on a high bond potentially.
Let me, because we got one comment that goes directly to that, and that's where I was going to be going in just a second. But John said, I belong to an association. They will get me a bail bondsman and an attorney while I am in police custody. Now, Mike and Alex, both you and I, you're part of it, and I, through the Polite Society podcast, have a relationship with the Armed Citizens Legal Defense Network. There are a lot of them out there. Texas, U.S. Law Shield, USCCA. There's a lot of places that do this. But I personally, guys, think it's important that if you own a gun, you do belong to one of these organizations. Yeah,
I agree. Totally agree, Paul. I mean, if you're arrested and put in jail and you're held on a bond, if there actually was a discharge of the firearm, you could be held on an extremely burdensome bond. The bond could be upward of $50,000, $100,000, even more potentially. So these organizations, like you say, there are lots of different organizations, and they have varying levels of service. So do your research. Armed Citizens Legal Defense Network is a great one. USCCA provides some products, U.S. Law Shield. There are various others, but they can be very beneficial if you do find yourself in this situation.
Yeah, and first of all, I want to disclose, I mean, I'm very biased. Marty Hayes and Gila, I think, are great folks. We're affiliate attorneys, but that's where I sent my money before I ever knew Gila or Marty. So maybe that says something. But, one of the things I know that they provide, and I think other organizations, is the education. The newsletter every month, the information you get when you become a member. Those are all educational things as well. And I think it ties into what we talked about in the beginning, and that is you have to prepare for the aftermath. You may win the defensive gun use, but you've got to also win the legal battle. And if you're in certain jurisdictions in this country, there's going to be a legal battle because they're so anti-gun in all likelihood. So it's the education that those organizations can provide as well. I don't want to tell anybody they have to have it. I belong to the Armed Citizens Legal Defense Network. Folks need to make their own decision, but I think they should consider an ACLDN or a similar organization.
I agree with that. I'm a member of ACLDN and I'm a member of Texas or U.S. Law Shield, so I'm covered twice, and I can say absolutely certainly you may end up needing, and you guys are aware of this as well. You could end up needing their services without ever having fired a shot.
Yes.
Alex had a case the beginning of this week, a phone call
About that exact situation.
That exact situation.
Yeah.
So
I get those phone calls far more often than a self-defense encounter where there is a shot fired.
yeah, because folks, for instance, in Indiana, pointing a loaded firearm is a felony. And according to our case law, and once again, I'm talking about Indiana, pointing a loaded firearm is the use of deadly force. So even if you point a firearm in the state of Indiana, you ought to be justified to use point a firearm at somebody. You need to be justified in using deadly force at that moment. Is going to be the argument.
All right, one more comment, and then we're going to start shutting it down. Like Ron Tater Salad White said, he had the right to remain silent. He did not have the ability. So, I want to go back to that one more time. You've just been through a highly stressful situation. Hopefully you have not been consuming alcohol, but even so, in a highly stressful situation, man, you want to tell your story. You want to talk. Try, in my opinion is, and I'm sure you guys would, try to limit what you say to the police to what's exactly pertinent in that moment. Understand that you're going to need some legal help. Hopefully you've been in contact and are a member of some place that will give you that help, and then keep your mouth shut.
Yeah, it's a natural reaction to want to defend ourselves, and we do that verbally. So it's going to be very difficult. I think it's a training issue. So you're going to have to make the decision. And frankly, most of the people that I encounter probably would have a hard time with option 2 that we've discussed today. But I think it's probably the best option if you're trained and have the ability to pull it off.
Amen.
Yeah.
And I know I'd be in deep trouble because, because of my job, I love to talk. So,
well, at the same time, Paul, if you use a gun effectively and safely to defend yourself, that's a pretty high level of skill. So maybe we can train ourselves to also have the level of skill to deal with the aftermath as well.
Quite possibly. Well, gentlemen, we've run already over the time we wanted to hit today, but I want to thank you so much for talking about this with us today.
Thanks for having us.
Thanks, Paul. Appreciate it.
All right, folks, we're going to go ahead and set it aside there. Come join us tomorrow for the Weekly Bullet. Tomorrow's guest will be Sarah Cade Hauptman. She is of the Guns Guide to Liberals podcast. We'll be talking with her about effective communication. I think it's going to be a great show. Please come watch us noon tomorrow, Central Time, and that'll be on both the Facebook and the YouTube feeds. For today, have a great Friday. Thanks for watching. We'll see you tomorrow.